In 1900, Great Britain, including a contingent from Australia, were at war with the Boer separatists in South Africa. The transport steamer Winkfield was carrying remounts, fresh horses for the army, but it found itself in fog off the South African port of Cape Town. There was a collision in the fog between the Winkfield and another steamboat, the Mexican. The Hobart Mercury reported the impact was terrific, but the discipline aboard was perfect, and to this may be attributed the absence of loss among the living freight. Most of the mails carried by the Mexican have been saved. That last sentence may have been somewhat optimistic. Many of the mails might well have been saved, but many letters and parcels were also lost. The Postmaster General commenced an action against the Winkfield and those responsible for the Winkfield for damages for the lost letters and parcels, and the Postmaster General undertook to the court to distribute those damages among the owners of the mail. The defendant objected that the Postmaster General was never anything more than a bailee of the letters and parcels. The Postmaster General did not own any of the mail for which damages were now being sought. The court confirmed that in tort law, if a tort involves interference with goods, an action may be brought by a person in possession of those goods. It is not necessary for the action to be brought by the owner, the person with title. The Master of the Rolls, Sir Richard Collins, said, "Against a wrongdoer, possession is title. It is not open to a wrongdoer to inquire into the nature or limitation of the possessor's right, and unless it is competent for him to do so, the question of his relation to or liability towards the true owner cannot come into the discussion at all. And therefore, as between those two parties, full damages have to be paid without any further inquiry." The court did note that under the law of bailment, the bailor, that is, the person who placed goods in the possession of another, could call upon that person to account for the goods. But this was an entirely separate question which had nothing to do with the responsibilities of the tortfeasor. From this case, we confirm that a person with possession of goods has standing to sue in relation to any tortious interference with those goods.